So good morning and thank you for joining us for this Policy Interested Parties meeting. I'm Amelia Boyd and I'm the Program Manager for the Medical Commission. This meeting is being recorded. The purpose of this meeting is to collaborate with interested parties such as the public, association members, physicians, and physician assistants regarding our policies, guidance documents, and interpretive statements. The documents which will be discussed here today are available on the policy meetings page on our website, which is wmc.wa.gov. Dr. Pam Kohlmeyer is the presenter for these meetings. Attendees, if you would like to ask a question or speak, please use the raise your hand function or the chat. When commenting, we request you avoid commenting on ongoing investigations or disciplinary cases. Please make sure your comments pertain to the agenda items. Are there any questions? That appear to be. So with that, I will hand it over to Dr. Kohlmeyer and I will get the screen share set up.
Great, thanks, Amelia. So like Amelia said, this is the opportunity that we're trying to get input, whether it's stakeholders, even staff, if they pick up something while we're talking. We're looking at two brand new draft policies. So we're really looking for input, especially on those two. The other one is a procedure that we've had for a bit, but it's ripe for some tweaking. And so this was presented at the last interested parties meeting, and through discussions and kind of enlightenment on different things, we realized that we actually need to put more effort into updating this procedure. And so that's why it's coming back today to be discussed. And I have to tell you, I've looked at this procedure probably over 100 times. And just this morning at like 9:30, I'm looking at it and I'm like, medical students and residents. What about PA students? Like I didn't even think about that before. So I obviously didn't have time to research it, but I am curious if anyone has input about if PAs have been discussed before with this. But anyway, it is open for discussion, and Amelia is going to pull up the procedure draft. It's in the, I guess, the packet. There are a couple of edits already that were pointed out between, Micah, who has great insight, Chris Bundy, who's just an amazing source of information with WPHP, to kind of condense a couple of sections that were a work in progress about how WPHP might be a part of this. And so when Amelia pulls up the draft that's in the packet, we'll talk through those three specific things and then whatever else you all want to discuss on it as well. And it's almost up. I can just sense it. There we go. Okay. So this is the procedure on processing complaints against medical students, resident physicians, and currently it says fellows as well, but for multiple reasons, it seems like that might be appropriate to drop off. The biggest reason being that fellows, basically, they've already gone through medical school, so they've learned about ethics and boundaries and all this stuff, standard of care. They've done a residency, like they've completed at least 3 years of postgraduate training, and now they're in their fellowship. And so to kind of treat them with kid gloves might not be in the best interest of the public. Anyway, so that's up for discussion too. But would anyone like to add something or ask questions or make comments? Now is a great time to do so. And if not, I'm going to tell you the things that I just thought about. So the one would be considering adding physician assistant students to this. So having a separate paragraph about that and adding them to the title as well. Does anyone have thoughts about PAs? Oh, I see a hand. Amelia, can you type and see who that is? Hillary Norris, do you want to speak? Unmute yourself and speak.
Oh, yeah. So thank you for the opportunity to share comment. Just want to clarify, Are we just talking about adding PAs right now, or is this general commentary that we have?
It can be both. You can make general stuff too.
Okay, great. So I don't have anything on PAs right now, adding them to the title. I think that might be helpful. Um, but I did get some feedback just from University of Washington, and they just had a few general comments as they kind of worked through the draft. Um, no major concerns. They just wanted to, let me see. Oh, for the provision on how the commission receives complaints on boundary violations, um, et cetera. They just wanted to know about how that the discipline will be applied for trainees with limited versus full licenses. Um, and then they also for the complaint process on limited licenses, they just suggested having the referral go to the sponsoring institution's leadership or GME office. And um, oh, they also just suggested having substantive findings regarding complaints or impacts on licenses reported um, to the employer or sponsoring institution, just in case it has employment impacts. So those were the notes that we got back, but they're just kind of still reviewing and sort of working through, but no major concerns were raised.
Okay. Yeah, I think.
So thank you.
Oh, of course. Yeah, I think after today too, we can have a discussion to get more details on that.
Oh yeah, that would be great. And I'll bring that back to them.
Perfect.
Thank you.
Does anyone have a comment about what Hillary said or anything else? Seeing none, right now I'll just talk about the couple of changes that I have after Micah's comments and Chris Bundy's. If you scroll down, I mean, there are working edits in this about if we add the PAs that all wordsmith, because we could use parts of just saying students if we've already said it's PAs and medical students. So scroll down. And this is more significant, I think, trying to strike that balance, keep going, strike that balance of saying enough detail that people know what's going to happen if there's a complaint filed against them if they're in training versus not being so ultra specific that we're in the weeds. And anyway, keep going. Yeah, in the procedure, here we go, keep going. So it's this bullet point that has all the highlights, the third one. So basically, if we remove after the first sentence where it says, if WPHP determines blah, 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 all of that can go away from that point to the end, except the or, leave the or at the very end. And the semicolon, yeah. And get rid of that period. Did you get rid of the period too? Yeah. So basically what it says is the option is that if there's reason to believe there might be an impairment issue or a health issue, that it could be referred to WPHP. That's enough information for this. And if we like that, we'll do the same thing in the next section that talks about the resident procedure. Yep. Even further up, start with if WPHP determines. Yep. And I am interested in feedback, even if you didn't plan to speak today, if you like that suggestion or not. Silence. Okay, we'll take that as a sign of approval. If you don't like it, speak now or forever hold your peace, or email me afterwards. That's fine too. Just of note, my email is pamela.comeyer@wmc.wa.gov, and I'll put it in the notes in a second. All right. Any other comments about the medical student policy or procedure? I think that this is good. Like, I think that it's nice that we mentioned about WPHP, and it's nice too that it strikes a balance of recognizing that people in training are in training for a reason. They're not held to the same standard of care as someone who's been doing this for 10 years, fully licensed with a lot of experience. But if they're touching people inappropriately, if they get a felony conviction, I mean, whatever, that kind of stuff, you don't get kid gloves for that. So it is nice to have that spelled out a little bit better. Gina.
Hello. I think that it's great. I also think that the addition of WPHP at this point in the process offers a path to rehabilitation that might not otherwise present itself in the course of training. And so I agree that this is really great.
Thank you. Appreciate that insight. I actually really agree too. I mean, the commissioners are the ones that'll, eventually decide whether or not to go this direction. But the sooner that you identify a health condition in a provider and get them the help that they need, the more likely it is to be successful, and that they can keep treating patients healthy, in a healthy way. So it's kind of good for everybody. All right. I saw a thumbs up. No other discussion? I guess we can move on to the next one. And like I said, it really was about the 101th time that I saw this thought of, oh, we don't mention PAs at all. So if you see something that you didn't think of in this moment, please email me afterwards. Okay, so really looking for some input on these next two items. They're both policies. Policies carry a significant amount of weight, not as much strength as rules, but there's a big process that involves the secretary's office too to approve these. And so talking about how commissioners should, kind of recognize if there's a conflict of interest and how to address that to ensure that there is fairness in everything related to the commission as far as rulemaking, discipline, all of that. And Kyle, who I see just let us see him, he was the mastermind between trying to get this going. So Kyle, you want to make some comments?
Yeah, thanks, Pam. Can everybody hear me okay?
Mhm.
I've been having sound issues. I guess it's IT issue of du jour today is sound. So this is meant to be both outward facing to interested parties and the licensee community, but it's also meant to be inward facing, and it's really designed to make sure that we are observing not only the relevant laws, but also addressing concerns that we've heard periodically. And again, probably for the best way to phrase that is kind of off the record. We've had a number of folks over the years kind of comment specifically on the disciplinary process and whether or not commission members who are involved in their view, should be. And so this, I have no doubt that this will be kind of a continuing conversation. This was brought up and discussed briefly at a commissioner retreat in terms of whether or not we should have something more formal than what we do now. And so that this is the probably the middle point of this process. And so I'm really interested, and as Pam mentioned, we do need input here, both from commission members, but also from interested parties and the licensee community. I'm going to talk briefly about conflicts of interest, which are generally governed by law. And just as an anecdotal observation, we don't have a ton of issues there. We don't have a ton of people who are making decisions on the commission that are going to have a direct a cognizable financial impact, or some sort of pecuniary underlying interest where they're making a decision about something that could ostensibly benefit them. And so I think that Pam's done a wonderful job of talking about the conflicts of interest provision. Pam, I believe some of the conflicts of interest portion was borrowed from nursing, which has had a long-standing policy about this. The and the intersection of what the nursing commission does is a little bit different than what the medical commission does, because they have a component that talks a lot about educational programs for both nurses and nursing assistants. There's not really a corollary to what we do regarding conflicts of interest. And again, I'll call those direct conflicts of interest. The other parts of this touch on a judicial doctrine called appearance of fairness. And that's a little bit more, it's a little bit more gray in terms of when and where a commission member should be cognizant of an appearance of fairness issue. So when I've talked to the commission members before, what they want or what they've asked for is kind of an easy way to kind of figure out whether or not they should. And typically from on the legal staff side of things, we try and establish, I guess in some ways it would be a conservative policy, but it's also a broad policy. And when in doubt, we ask commission members to kind of step off. One thing I don't think that the majority of the licensee community and other interested parties, Hillary, I know you're here. I would certainly welcome your input here. But one thing that's not very well understood is the amount of redaction that staff does for commission members. The vast majority of the time, and I'm happy to talk about specifics if there are specific questions, the vast majority of the time, the commission members, when they're dealing with licensing and disciplinary matters, do not know the identity of the individual respondent. Our case authorization packets are completely redacted, and our case review discussions, again, the only person there's one commission member who knows the identity of an individual. And when I say identity, I mean location, practice. They probably, and certainly the name. And so that material, when commission members are making decisions on disciplinary matters or licensing matters, is not known to them. They are relying on staff and reviewing commission member on case reviews to know those details. They do not. And so sometimes I think that can make it difficult for a commission member to know when they might have a potential conflict of interest in the appearance of fairness sense. So Pam, I'm going to leave it there and turn it over to the folks who are on the call. But again, I want to stress that we take great pains to avoid appearance of fairness issues because of the nature of our disciplinary system that's set up. But again, I think that this is a time to kind of formalize at least some general principles in this regard. But again, I look forward to comments from not only commission members, but also the interested party community.
Thank you, Kyle. That was very helpful. And Kyle's been huge in giving me documents to think about in drafting this. And so we have a good draft, but now we're trying to polish it. So who wants to weigh in next? Chris Bundy, did you put your camera on because you want to say something intelligent to the rest of us? We just get to see your face. That's great. No, don't worry. Scott Rogers, go ahead.
Hi, thanks. And I'll start my camera, just give you some advanced warning. I was just wondering whether it was really the intent that commissioners recuse themselves from hearings if they've ever had any dealings with any of the other attorneys in the case. And the reason I ask that is I know FSMB and other states try to have attempted to have at least one medical malpractice attorney on the commission. I'm a medical malpractice attorney on the commission, and I can't imagine many hearings where I have not been in cases mostly against the attorneys who are representing the respondents. I can say, and I'm just wondering, I can see how that could possibly be an appearance of conflict. I can say objectively that there's generally a lot of respect and trust and camaraderie among the attorneys, and it even on opposing sides, and it really doesn't affect at all the ultimate decision of this client or the respondent's matter that is in our hands. And if that's the case, my second question is, given that attorneys general are always the attorneys on behalf of the medical commission, is there any medical commissioner who could possibly sit on an adjudicative hearing if knowledge of or being on one or the other side of the case with an attorney is really intended to create a conflict? That's my only comment about that. I don't expect a resolution today, but thank you.
That was very insightful. Thank you for that comparison with the AAGs. Do you think it would be better if it just talked about like if it was an attorney within your own practice, or somehow rewording that it's more of a familial type situation?
Well, and I think that it's really a question for what is going to be the public's perception. Obviously, if there is an attorney in a commissioner's firm who is who is representing a respondent, then that's clearly a conflict of interest. Legally, there's a financial interest in the outcome, or could be a financial interest in the outcome. So, and also there are other situations. For example, this has come up where I would never sit on a case or make any decision. I would recuse myself entirely if there were ever a complainant who is being represented by me or my firm. That type of thing does come up. That's clearly a conflict of interest, but the notion that, for example, Fane Anderson has several medical malpractice attorneys who represent defendants on their side. I've represented people many times and had attorneys from Fane Anderson or Favros Law, I think is what they call it now, on my cases. And they also defend respondents before the commission. So if, for example, I am not allowed to sit on any panel where a Fane Anderson attorney is representing the respondent by virtue of my having represented a completely different client in a completely different manner, where a Fane Anderson attorney was representing a physician, separate matter, then I would be hard pressed to sit on probably any panel. And then the shadow portion of that is that all the commissioners work with all the AGs who represent the commission. So if having participated in litigation or an adjudicative hearing with another attorney on one side or the other is going to create a conflict, then it's impossible for any commission member to ever sit on any panel, because it's always going to be an AAG who represents the state and the department, and who does work with the commissioners. That's just my comment. I don't have a resolution for how to frame that, but yes, certainly I agree entirely with the sentiment that if there is a stake in the outcome, for example, if a commissioner is part of a firm representing a client with a medical malpractice lawsuit against the respondent, then obviously there is great financial interest in the outcome of the administrative hearing. That would be a clear conflict. Stating that I would agree with stating that, but really my question is, how far did we want to go from that situation where there's a clear conflict to any possible involvement with any litigation or adjudicative hearing where another attorney was part of that? Seems to me so far to the other extreme that that no commissioner could ever serve on a panel, or at most could only serve on one with one AG and then never again. So that's just my comment on the language. Obviously, we can take it back in wordcraft. I'm just for this purpose, I just wanted to clarify what really is the intent of that provision. Thank you.
Thank you. That was very insightful. Kyle.
Yeah, so Scott, I can talk a little bit about the thoughts with regard to that particular provision. And again, as Pam highlighted, Scott, we're at a point where we're trying to put these together in a kind of thoughtful way. So this is not a finished product by any stretch. So thank you for the feedback. That's incredibly important that we get this, especially because, again, this is meant to be not only an outward facing document, but also something that, the commission members are mindful of. So with two points that I'd like to raise, and one of them is something that I feel pretty strongly about. Historically, when we look at appearance of fairness, we almost always do it through a lens of looking at commission members or staff that know a respondent, right? And so if we're having an administrative adjudicative hearing, and again, we don't have very many of them, but I think it's still important. The part that gets lost sometimes in that analysis is how our hearings and how our process appears to patients or complainants. And there's a common perception in the public of the commission, and it's frankly it's board and commissions in general, not just medical commissions, and certainly not just in Washington, where there's a sentiment on the public part that these self-regulating professions go to some length to protect their own, right? And so in some ways, while the medical commission is or a state medical board is responsible for licensing and regulating the conduct of physicians, there's always a public perception that that state medical board is kind of trying to go overboard and help and be kind and thoughtful to respondents to the detriment of patients. The flip side of that, of course, is we do get frequent comments from folks out in the community that, think we're too tough, that we're too rigorous when we investigate and review complaints involving physicians or physician assistants. And so, there's always that public perception, and the appearance of fairness doctrine is meant to address at least part of that. And so we have to be mindful of the fact that if somebody on a hearing panel, for example, knows opposing counsel, maybe they're golfing buddies, or, maybe they went to school together, or, maybe they're part of an alumni organization that, in common, even though it's a lawyer and a doctor or a public member like yourself, Scott. I do think that we need to be mindful of the way that our adjudicative hearings appear to members of the public and not just respondents. So there's that. The other part with regard to the AGs, that is the system that the legislature has given us. The reason, the case that Pam cited in the draft policy, the Johnston case from the 80s, actually addresses the issue of having advice AAGs and litigating AAGs. And that's why we have an advisor from the Ag Health Division, but it is the Government Compliance Enforcement division that does the prosecution. And so, again, that's sort of baked into the equation, and there's not a solution absent, some sort of change in the law for how we do this. So again, Scott, I appreciate the comments. I think that those are useful, and we need to be mindful of that. I would invite Scott, if you have suggestions in terms of ways to address this or refine the approach that we're taking here, please do not hesitate to send comments in to Pam or myself. As Pam mentioned, we're doing it at the behest of the commission. It's time to kind of formalize something. So if you have input, please do not hesitate to send it our way.
So I certainly will, and I'm a member of the policy committee too, and I really wasn't opposing anything, just kind of tossing out the issues and seeing if there's any additional public comment for us to take into consideration. So, and I applaud. I'm, for the record, I'm wholly in support of putting some language around these and letting the public know where we stand. Thank you so much.
Yeah, I tend to like to make comparisons between like the legal profession and medicine. And it might be a little bit similar, and I'm just thinking on the fly, but if you have a hearing on a disciplinary matter against some neurosurgical thing that went bad, in some ways it's nice to have a neurosurgeon being on the hearing panel to decide if the standard of care was really breached. And they might be in the same neurosurgical society, and they might be friendly when they go to conferences. And does that mean they should be recused? A little bit similar to what you said, where if you're in the medical malpractice arena, you're going to know these med mal attorneys because there aren't a lot of them. Well, I mean, there are some, but it's kind of a more narrow world. So, yeah, I think if maybe Scott, you and I can talk offline, maybe we can get the wording that seems to address all of that, knowing we can't be perfect with any of this. And a first time policy is ripe for edits in 4 years, right? And with something like this, where it's, I think that we're close because, Kyle talked about it with the commission in the fall or whatever. So there was already some feedback. The nursing commission has addressed this. So we have some input to help us. It's not like we're just, on the fly. But we're not going to have it perfect from the get-go. But it would be nice to try to have it be as fair and reasonable as possible. And if we make it too tight, there are going to be no commissioners available to sit on a hearing, right? Because everybody's going to have a conflict. So with that in mind, Scott, I would really appreciate your feedback and input offline. All right, who else? The beauty of this is that it really is trying to promote fairness in adjudication. And so the thought behind it is good. It's just trying to make sure we word it as well as we can to make it effective. All right, I think we can move on to the next one then. This one too, we also want a lot of input because it's a brand new policy draft. And this one has to do with something that I am not the IT guru, among the staff. It's on artificial intelligence, also assistive intelligence technology. Having a policy is pretty cutting edge in the fact that the FSMB just what, like a month or maybe two ago, just published some guidance type stuff on it. And the reality is this technology is taking off so fast, it's hard to stay on top of it. You know, policy development takes a while, and the technology itself is taking off. And so it's hard to create a policy that's going to address something as it keeps evolving. But we are really looking for input to try to get language that we're happy with at the moment, that seems reasonable, helpful, while still not being so constricting in a way that is unfair to providers and confusing for patients or whatever. So looking for input, especially if you understand technology. I see a hand. Frank Myers.
Hello, Frank Myers with the FSMB. No real input. We just generally agree. It's the sections that refer to our policy, and we're available if there's ever any questions about those, or if any way we could assist in any way in this policy. But generally, that's really about it. Just wanted to say we appreciate Washington's taking kind of the lead in looking at this and referencing the policy, and we agree it is a quickly evolving field. And I think this is something that, as you mentioned with the last policy, the speed at which it changes and things, it may end up seeing future iterations and future updates. So we're always available and willing to assist in any of those discussions or research that you or others may need.
Thank you so much. So I saw your name when we logged on, and I thought that must be a different Frank Myers. So Frank is amazing. He leads this education group. I hope you're okay with me saying this, of the lawyers that help support medical commissions across the nation. And he's awesome. So thank you. I will pick your brain offline, because I would love your insight on this.
I did not pay her for those comments, but I appreciate them nonetheless.
Yeah. Oh, awesome. All right, who else wants to weigh in? Please do, because this really is the time to give some input on this. Sometimes less is more too, like if there are parts of it that you want removed. Scott Rogers.
Sorry again, I don't want to make this the Scott show, but interestingly, I will provide some comments offline and maybe we can incorporate them. Interestingly, I just got an MS in computer science a month ago with artificial intelligence and machine learning focus. So I have a lot to say to this, but to your point, that was 1 month ago and it's already obsolete. And Mr. Myers, I'd be glad if there's any way that I can assist with FSMB on this as well. But I think that I like the policy that's been put out. There's a lot of thought that's gone into it.
Thank you. Boy, Scott, you never seek to amaze me. I can't believe you had time to do another degree. That's awesome.
It's just a nasty, expensive habit.
Well, it's helpful too and timely for us.
My grandfather said that you had an expression, that and a quarter will get you a cup of coffee. But I have updated that with the National Bureau of Economic Research's Consumer Price Index. So I say that and about $6.50 will get you a cup of coffee.
Yeah, that's about right. Awesome. Well, thanks, Scott. All right, Micah.
Thanks. So I just wanted to provide some background about what's happening in Washington State, just so people appreciate that they're, I guess, the lane that we're trying to stay in. So the first is there's an executive order on artificial intelligence that Governor Inslee has put forward, and that really is directing state agencies to work with Department of Enterprise Services in utilizing artificial intelligence in their internal processes. So that's the first bucket. The second one is a bill was passed in the 2024 session that directs various stakeholder groups, agencies, to look at artificial intelligence solutions and come up with a framework for how state agencies use it and point it towards the public. That is not the focus of this particular thing. This is talking about use of artificial or assistive intelligence in the practice of medicine when you're aware that it's there. And I will go ahead and say that the policy piece of this, as opposed to the guidance piece, is really intended to evolve as the knowledge of the practitioner and the patient evolves. I do anticipate that, like commenter said, there will be revisions. This is definitely just a starting point to provide the widest of guardrails, and to still allow not permissionless innovation, to coin a term that sometimes we disagree with, but to allow innovation and utilization, research, and design to still occur within the practice of medicine, but making sure that there's awareness on both sides. The other thing that, and Pam, you can correct me if I'm wrong, there was a bill that was passed called the Uniform Telehealth Act, and it effectively replaced our longstanding telemedicine policy that has been received quite well in the state and nationally. But at the end of that policy was some suggested AI guidelines, as well as some suggestions to go do some CME on specifically bias in populations that are used to train an AI. And so thereby the bias gets translated into the AI and the responses it could come up with. And so because the Uniform Telehealth Law was passed and it will become active tomorrow.
Today, well.
Oh, today?
Mhm.
Then
That's next on the agenda, but yeah, go ahead, keep going.
it means that our lovely telemedicine policy is now superseded by statute. So we have to repeal it, and thereby repealing the AI portion. So that's the other generating factor with coming up with an actual AI dedicated policy.
Thank you, Micah. That was very helpful and articulate. All right, as far as the wording of this itself, is there something that we've missed? Are there things that are too detailed? Anything that's inaccurate? I won't take offense. This is the time to make it beautiful. Yeah, I know there's some things. I found a couple of things myself this morning, so don't be afraid to speak up. Scott Rogers.
Well, darn it, I will be very brief. One question that I had in here, and it is possible that the new definition of AI addresses this, but there are older types of AI, especially those that emerged in the 80s and 90s, and they fall under what were called then decision support systems. There were things that were, and this, interestingly, the biggest application was in medical and healthcare, and they were things like using ICD and CPT and HCPCS codes and things, and developing symptoms and predicting possible etiologies. And one could argue that even some of the information, like up to date, could theoretically fall under some type of that thing. So I just want to make sure that if we're going to require informed consent to even use AI, that we make sure that the definition is not so broad as to sweep in any type of information system. And that's one fuzzy area that I see. I like this definition, and I believe that this definition could arguably exclude that. I'm just setting out something that could be on the horizon.
Thank you for that. And that's a good thing that we want to make clear in the policy somehow, is that when we first were beginning to draft this, there was a discussion about, patients must consent to this. And I was thinking, like, when I was practicing emergency medicine, and I'm going to date myself, but the EKGs would have the, the reading, it wasn't your reading, but it was what the, AI type stuff decided you should be worried about. No one ever consented to that being used on them ever. Never thought about it. It was just a tool that could help the provider, but they still, look at that, make their own interpretation and respond. But if it says must every time AI is used, like I think almost every physician might be at risk of accidentally tripping up when they don't mean to. So Scott, I appreciate you saying that. And with your new degree, I'd love to help put it to work to make sure we end up with great language on that.
Glad to
That
help.
was
That
helpful.
might be the only use for it.
Great. All right, who else? Oh, all right. Well, seeing none, seriously, reach out to me afterwards if you have anything to add to this, because, don't be worried. It will evolve. Like this policy, it's going to be whatever is passed in the near future, but it's going to evolve. And so trying to get it as accurate as we can for what we know at this moment takes all of us, because we each have different skill sets. Mine is not IT, so I find irony in the fact I'm writing an AI policy, but with your input from the rest of you, it all comes together. All right, so the last thing before we have open forum. So just like Micah said, he was not a plant. He did that on his own spontaneously. So today, ESSB 5481, the Uniform Telehealth Act, became effective. Yes. And because of that, our telehealth policy has now been basically superseded by this statute. And also of note, as Micah said, on the last page, about this much space, had addressed AI, artificial intelligence. And so because of that, it's very timely that we have the AI policy that we're going to be hopefully adopting at the next business meeting. And, oh yeah, there it is. And that we will be recommending repealing the current telehealth policy that the commission has, because it's basically defunct. I mean, it's been superseded by this statute that has gone into effect as of today. So any input on that? Great, because we're pretty powerless about that anyway. So it kind of is what it is. All right.
Pam,
So
I'm
yeah.
sorry, Pam, it's Kyle. I do think that it would be useful to have a really short cover memo for the policy committee to explain what you just did. So certainly folks who can't make the policy committee meeting itself are aware of why we're doing this. It can be literally a paragraph at most, but if you don't mind doing that for policy, I think that would be great. Amelia, is that something that we can accommodate?
Absolutely.
Would love to do it. Great idea. All right, so that moves us into the open forum, and we started this for the first time at our last interested parties. And Amelia, do you want to read the little blurb?
I'm working on it. Hold, please.
Okay, well, while she's working on it, this is the opportunity for the commission to hear from you about ideas that you have, concerns you have, not specific to particular cases. But so the policy committee can have it on their radar and see if it's time to do some kind of update or to develop a new policy, interpretive statement, guidance document, procedure.
Okay, here we basically what Pam just said, and that's a time where interested parties like you can share your thoughts and suggestions on the WMC's policies. We encourage everyone to participate and express their ideas respectfully. To ensure that all those who choose to participate have the opportunity to speak, please limit your comments to 2 minutes. If you have an idea for a policy or suggestions to reform an existing policy, please use the raise hand feature within the Teams application and you will be called upon when it's your turn to speak. When sharing, please remember the WMC regulates allopathic physicians or MDs and physician assistants. If you have an idea for a different profession, feel free to send it to the email address on the screen and we will forward it to the right place.
Is there anything weighing on anyone's mind? Well, if there's not, it looks like our work here might be done. Looks like we're going to give you 10 minutes back of your day. If you think of anything, though, please reach out, because our fearless leader of the policy committee, Chris Blake, is amazing. And she really does like to have public input and stakeholder input. And so please reach out. I put my email in the chat, and feel free to reach out anytime. Okay, Amelia, back to you.
Thank you, everyone.